And my lords, specifically page 5 of that list of authorities of the rules of procedure, that is page 5. My lord, a motion means a proposal made by a member that Parliament or a committee of Parliament doing something, order something to be done, or express an opinion concerning some matter. That is the motion. While a bill, if you look at page 1 of the Rules of Procedure of Parliament, means the draft of an act of Parliament and includes both a private member's bill and a government bill. So, my lord, there is a distinction between the two. There is a distinction between the two. My lords, it is the evidence of Mr. Keith Muhakanisi, that is in the respondent's affidavits in support of all the answers to the petitions, that is paragraphs 5-2, that the office, when this bill was presented, to the Ministry of Finance, it was examined. It was examined, and as a result, a certificate was issued. My lords, the certificate that was issued, which we managed to attach the respondent's additional answer in support, is of the opinion, and these are technocrats, their job is to look at issues to do with finances. What challenges shall we have in introducing this bill financially?
Also, can a certificate be an opinion, or does it certify something?
My lord, it certifies. I must oblige my lord for the correction. So, my lord, they certified that the bill introduced by the Honorable Magezi was budget neutral.
No. Where does it say? The one I have here says that there will be no additional financial obligation.
My lord, read it until you reach the end.
No. You tell me where that is so different.
Most obliged, my lord. Let me direct them.
I have the one for Mbale Society.
Most obliged. Let me direct them.
Unless you are importing what Mr. Muhakanisi might have said in his affidavit. The affidavit is not a certificate.
Mine is 29th March.
My lord, I refer you to page 3 of the certificate.
Not of the certificate of the affidavit.
My lord,
what does the certificate say?
my lord, that's what I'm taking to, but I prefer back to
What it is, what does it say?
my lords, funding and budgetary implementations. That is on page 5 of annexure C, which is a certificate of financial implications. There are no additional financial obligations beyond what is in
I
the
did hear you say that. You said it was budgeted.
My lords, that is the affidavit. I wanted to, and that's how I chose to deal with it. However, it says,
Give what plain meaning. That's what you said.
most obliged, my lord. But what is in the medium-term expenditure framework and thus the bill is budget neutral.
Now, go to the preceding page. Planned expenditure by major components of MTEF. The planned expenditure will be accommodated. The planned expenditure will be accommodated. There is expenditure, only that it will be accommodated. But the expenditure is there. The fact that there is money does not mean that money is not spent. The question is, does Article 93 require a certificate saying the money is available to do this, or it says there shall be no charge? My Lord, of any monies, you read the article, any monies. Yes. It says payment, issue or withdraw from the consolidated fund or public fund of Ghana, any monies, whether that money has been planned for, because it would have not been planned for the bill, because it would have been passed in a budget before the bill, of any monies. So, here it says there will be no addition.
My Lord,
so it actually means you can adjust the budget, you can get some money from the salaries of the state authorities,
no, my Lord.
loading syndrome victims, and you.
My Lord, the import of 93 restricts. It has riders, and those are provided for in A1 to 4. Were either otherwise done by reduction. They make the implication financial, but it is by reduction.
And otherwise by reduction.
Yes, my Lord.
So if the bill has the effect of reducing expenditure, if it has an effect of touching 1 shilling on the budget,
and my Lord, that is our position.
But has to be brought by government. You see, that's the good thing. It's not that law cannot be brought. No, it can be brought, but not as a transit member state.
My Lord, I beg to differ, and this is where we actually have a point of departure. My Lord, a private member can bring a bill, even if it is going to create a charge. That charge is by way of reduction. The Constitution does not restrict that.
So for you, a charge means when it is increasing.
My Lord, from what I'm reading from Article 93, if it is increasing it, then please, a private member, stay away. Government, that is your job.
It does not say increase, it says charge. If it wanted to say increase, it would have said increase the budget. It says a charge on the consolidated fund.
Most obliged, my Lord.
It does not say increase the budget, no.
Most obliged, my Lord. That charge has to be by way of reduction. Not increasing, that charge has to be by way of reduction. That is a submission.
Are you sure where the reduction was?
My Lord,
As you answer that,
yes, my Lord.
go to Annex A of Mahakani's affidavit you are referring to. This is the Minister of Planning, Attention Permanent Secretary, Secretary Treasury. He's talking about request for certificate of financial implication. And in that he says, among other things, the object of the bill is to amend the Constitution, blah, blah, to increase the number of days within which the Electoral Commission is required to hold fresh elections. where presidential election is annulled and related matters. How can increase of days to hold fresh elections not have a charge?
My lords, if you could explain it to me.
I don't have to explain. There is an area which was not complained of about by the petitioners. You have not referred to it. It is that in the recommendations by the Supreme Court, implementing those recommendations would actually create an expense, and as a result, a bill making provision for the Supreme Court recommendations could only be brought by government.
My Lords, I invite my Lordships to the wording of Article 93. We are dealing with a bill, and 93A says Parliament shall not, unless the bill or the motion is introduced on behalf of the government, proceed upon a bill, including an amendment bill, that makes provision. The bill that makes provision. The operative words are that makes provision. Complete the sentence. Don't stop it. Makes provision. For any of the following. Makes provision. In other words, in the body of the bill.
Which bill have you ever seen in all the laws of Uganda? How many are there?
There are very many, my Lord. There are very, very many bills that make provision for imposing either taxation or reduction on the consolidated fund. Now, when it is a bill, what we look at is, does this bill, on the face of it, make provision? On the face of it, in its articles, does it make provisions for the imposition of taxation or alteration of taxation, otherwise than by reduction? At that stage of the bill, we are not looking at the effect of the bill. It's only when we come to motions that we look at the effect. Pursuant paragraph B of Article 93. Otherwise, if my lords insisted on that interpretation, it would be bizarre, because every bill, call it whatever name, has some impact on the consolidated fund.
But then, London, if that was the case, then why would you need a certificate? Because the bill is very clear. It doesn't say you will spend money on a referendum. It doesn't mention. What would the certificate be?
No, my lord. The certificate was important. Certify that the requirements of Article 93 are met. There is no imposition.
That is very interesting, because if you go to Muhakane's affidavit and you look, the object of the bill is to amend ETC, provide ETC, therefore to examine the bill as required under Section 76 of the Finance Act and issue a certificate. All that shows, in fact, in details. Then you go to Article, go to Hakan's affidavit, paragraph 7. I have been informed by my attorneys in Attorney General's chambers, whose information I very briefly to be true, that the provisions of Section 76(2 of the Public Finance Management Act explicitly state the object of the certificate of financial implication is to show the estimates of revenue and expenditure over the period not less than 2 years. It does not say that I should look at the bill and see whether it charges tax. And see after.
What about Attorney General that Roland? Maybe in the factual circumstance of this case, one thing that caused this petition. Maybe let's separate the motion from the bill. both, if you understood Mr. Mabirizi yesterday, both are an issue. Mr. Mabirizi says, even before you go to the bill, there was a motion seeking leave to introduce the bill. Let's deal with that. There was a motion. Was there a need for a certificate? And to determine whether there was a need for a certificate, you'd have to go to 93 and all the relevant provisions in the clauses and paragraphs. If you're seeking leave to bring a bill, do you change anything on the Constitution? When you deal with that, then let's come to when leave was granted. Now, you're going to introduce a bill. What was that bill? Is there anything in that bill which you know, once it passes law, it will bring a charge on the consolidated fund? As simple as this. My Lord, let me take it one by one. For the motion for leave to introduce a private member's bill, there are no financial implications. It's just a motion for leave. It is hard, determined, either granted or rejected. At that stage, no imposition of any charge on the consolidated fund. That's the motion. For the bill, my emphasis, my lords, is the wording. A bill. No, don't begin that way. We'll run into problems. I think that's why your junior colleague has run into problems. Let's begin with the factual situation before us. There was a bill that was brought by a private member. What was the bill about? What did it intend to achieve?
The bill had several clauses.
Yes.
None of those clauses provided for, because here we are talking about a bill that makes provision for. None of the emergency bills provided for.
That would be good if the certificate you are relying on did not go on to show the impacts of the expected outputs, the impacts of the bill on the economy.
Because
if it was just a question of just looking at the bill to see whether it imposes tax, I would the whole Minister of Finance give us a whole detail of the impact on the economy, and then go to expenditure, data components of MDEF, then go to tell us that is a planned expenditure which can be accommodated.
No, maybe my lords, the body of the certificate contained superfluous things.
really,
The conclusion,
really,
You
no.
are looking for superfluous certificates.
I am not the one who wrote the certificate.
No, you're the one who
The conclusion of the certificate was that the bill does not impose.
I think that's what you have just talked about it. What they call an afterthought.
No.
This argument.
It's not. I have been looking at the certificate.
Land Attorney General, I have read this letter by the Minister of Finance, I mean the certificate. He lists items. I thought the argument, and I don't know whether this is what the Minister meant, was that the activities that are coming out of this bill had already been budgeted for and are covered. And that this one would have nothing extra. That's why he says it is neutral. But now the way you are arguing...
Your colleague has just said it's budget neutral. It does not say that it is budget neutral as far as its provisions are concerned. No.
The conclusion of the certificate was this, and I read: funding and budgetary implications.
Yes.
There are no additional financial implications beyond what is in the medium term.
Is it within the wording of the bill?
No. For the Minister of Finance, they are looking at
The economy.
the medium term and the economy.
Yes.
So they are saying the medium term expenditure framework is not going to be affected by the introduction of the
So
bill.
would there be a charge on the
Not at all.
Absolutely. We agree
Yes.
with you.
Yes.
Therefore, it cannot be that Article 93 was referring to the wording of the bill to say we are creating a new tax or we are charging this. No. It was implications of the bill. The certificate is about implications of the bill when it has been passed. That's all for me.
Actually,
And now you have come up with a new argument saying, no, it's not about implementation. It's about the words that are...
When they say here on page 2B, that the plan expenditure will be accommodated within the MTF for the ministries, departments, what does that mean?
planning expenditure,
Yeah.
the ordinary government planning expenditure.
No, we're talking about
As I said, the certificate could contain superfluous, but you have to look at the conclusion.
All I can say is that Honorable Attendant, with all due respect, be serious.
Yes, Mr. Rollins, I thought you were still submitting.
Can you conclude? We've gone round and round and round.
Unlike the Constitution, all these petitions, they are affidavits, they are annexures. You should read them as a whole.
Most obliged, my Lord.
And you need to get a better understanding of the meaning, the import of the words, the clauses, the phrases in 93, especially when they say the effect of charging of the consolidated funds. I think this is where the problem is.
You run a dent of stating we have not read this book.
My Lord, I've read the petitions. My Lord, I'll deal with the mischief of Article 93. My Lords, the mischief Article 93 is intended to cure is A, not to put a strain on the consolidated fund, among others. B, for Parliament not to enact a law which will not, for Parliament not to enact a law which will not be implemented due to the non-availability of resources. My Lord, that is the mischief Article 93 is intended to cure. My Lords,
all the other bills can be brought and they can, money can be spent on them except the private members.
my Lord, that is our submission, my Lord. My Lords, I'll refer you to my Lords, I'll make an example of the mischief, and I'll refer to the Children's Act of 1996, which, my Lord, was a very good intended law for Uganda. It had very ambitious provisions, among which included setting up homes.
Was it a private member? Was it brought by a private member? 93 doesn't talk about that. It's about, and the issue here is about the private members fee. So don't bring us government bills which have failed to get money. Talk about the private members.
My Lord, it's our submission that the private members bill did not create a charge on the consolidated fund.
We have understood your plan.
Yes, ma'am.
We have understood you. But we're only saying, how do you bring the Children Act, which was a government?
My Lord, I was using it as a way of example, just to show, not necessarily related to private member, but the
I
mischief.
can also give you a private members bill which we helped to sponsor when I was an environmental activist of Kavera. When it was about to reach a certain stage, government removed it, took it over, and it's done.
When you see that the argument, is not, don't you have other areas?
So, even the private members,
because government feared that they would lose the tax money they levy on campaigns, so that would affect the consolidated fund.
yes. So the government took it back.
My lord, this was not the case in the private members'
You
bill.
that example of pushing for, you made your point.
My lord, I've made my point.
Yes.
My point is that the bill, the bill did not make provision for the imposition of the listed restrictions that are covered in Article 93. My lord, I so pray that you find. Yes, my lord.
Mr. Drole, for once you've caused me to get lost, and you should go to on the Guinness Book of Record for making me be lost, because you say, and I thought it was quite persuasive, the mischief. What are the mischief which Article 93 seeks to avert or to circumvent or to inhibit? You were quite good on it. Say, no, anything whose consequence, and these are your words, is to impact on the consolidated fund. And then at the end, you now ask us to say that this bill here has not made provision for. When it is not about the physical provision in the bill, but whose effect. It is either physically in the bill or even its own effect makes provision. There is need to make provision for affecting the consolidated fund. That was your good argument. Now you're saying no, this bill doesn't make provision. Do you genuinely believe that what the Attorney General told us, that there are various provisions in this bill, none of them would require government going to the consolidated fund to implement it? Is that what you are saying?
That is what I'm saying, my lord.
But none of those.
That is what I'm saying, my lord.
What about when it's involved? And added in new.
Exactly. Honorable, Council. Council, we would like to seek guidance. Honorable Magezi introduced a bill. He took to Parliament a bill, and it had 4 things. The first one, time to hold presidential, parliamentary, and local government elections, Article 61. The second one was the eligibility requirements for the standing of president. That is Articles 102 and 103. The third one was in respect of the number of days within which to file and determine the presidential election. And the fourth one was to increase the number of days within which the Electoral Commission is required to hold a fresh election in the case of a successful presidential election petition. Those were the 4 in his bill, right? Now, by the time the act which is now being questioned, other matters had been put in, all right, including one of increasing the term, the period of Parliament from 5 to 7 years, all right?
By a private member's motion, by the way, in the discussion of the bill.
There was also increase of the term of the period of local councils. All right? Now, if a bill so there was also the amendment for restoration of term limits, all right?
Not by government, but by another private.
But by another private member.
Not by a bill, but by a motion.
Now, when you refer to the certificate of financial implications, are you referring, does it relate to the original bill of Honorable Majesty, or does it relate to the transformed bill? Right? And are you still contending that after this bill had been transformed into ultimately what came out was the act, that there was still compliance with the provisions of Article 93 of the Constitution? We would like to be guided on that.
Actually, to help my learned brother, to add to what my learned brother said, isn't it a fact that the act, the amending act, which is now being challenged, when it became law, it has necessitated the holding of a referendum, and if you hold a referendum, doesn't it directly charge on the consolidated fund as a consequence of passing this act? My lords, Article 93 refers to the time the bill is being introduced in Parliament. The mischief is as was stipulated by my land friend.
At the beginning, it has no financial implication. And by the time it metamorphoses into an act, it has serious implications. Then what would have been the purpose of
that is why
the mischief would not have been addressed.
My lords, that is why when it metamorphosed, when it evolved another certificate of financial implications was obtained, taking into consideration the new additions. Having said that, our strong submission, and that's our submission, is that we are looking at the entry of the bill into Parliament, not at the effect. Not at the exit, not at the effect, not at the exit. When the bill is introduced in Parliament. That is the plain interpretation of Article 93. And it has been our submission that a bill for the amendment of the Constitution is a bill like any other.
So we have understood that.
It evolves.
You've been, Attorney General, you've been clear on that one. We are not adding value. You've said it many times. We have understood that one.
So I think we better close it at that.
No, we have understood you. Whether we agree with you or not is a different matter.
Precisely, my lord.
I want to assure you we have understood.
I think we have done our best to convince your lordship.
I don't know about this. You've done all that you can.
That is our understanding of the interpretation of this article.
Councillor Elias Lupago, you wanted to say something?
Yeah, my lord, we wanted to follow the submission because we are recording here.
Yes.
There's been mention of a second certificate. We wanted to be guided where to trace
They
it.
are not evident.
They're not. No, the court made this ruling. Councillor Lupago, I can help you.
Yes.
It emerged yesterday. Our attention was drawn by Mr. Mabirizi submitting for himself that contrary to this talk here, that there was one certificate, from the evidence on record, the parliamentary proceedings, the answer, there is mention of a second certificate which was put in on the floor of Parliament midstream. And it necessitated us, in the interest of justice, to order today that when the clerk of parliament comes next Tuesday, he must come with all the certificates, and all includes the other one. I think you hadn't come in probably.
No, I was around, but I thought it was on record here. I thought they have it here.
No. Actually, the reason was it's okay. The reason why we ordered was because it is not on record.
My Lord, Honorable Attorney General, again I'm seeking the guidance. You said what is material is the entry of the bill. That is when Article 93
comes into play.
Very well. Now, but the language of the article is, Parliament shall not proceed upon a bill, including an amendment bill, that makes provision for any of the following. Doesn't this impose an obligation on Parliament that once, when dealing with a bill of a private member, once an item is brought in, whether by amendment or otherwise, that affects any of the provisions of Article 93, then Parliament ought not to proceed?
Yes, my Lord.
Now, was it done in this case?
Yes, my Lord. How it was done is by seeking certification from the people in charge of finances whether the bill introduces a charge. Yes, and then those in charge of the coffers came back and said the bill does not impose the charge on the constitution.
Supposing this court finds that contrary to the certification, the bill actually does.
If they had said it does.
No, court. Now they've said it does not.
Yes.
Supposing court is persuaded on the evidence that actually it has implications on its consequences being charged on the consolidated fund.
Is it true or is it not that there is an intention to hold a referendum following this act?
As of today, that is speculative. Yes.
That's
we could, we may not.
I see.
Yes, it is speculative as of today.
No, if this court does not nullify the amending act, or does not nullify certain provisions of the act which flow naturally into the holding of election, if it is not done, isn't it? That's what my brother is asking. Is it true or not that there is need to hold an election consequent to amending the constitution?
No. The people of Uganda, you see, the constitution now is amended. It has two different terms. When this court has finally certified it that it's okay, as indeed we pray that it does, then the people of Uganda will look at the constitution and find out whether they want to harmonize the terms. Otherwise, they can decide to leave it as it is.
But there is that possibility of doing that.
There is a possibility of doing that, and there is a possibility of not doing it.
Yes, and that is why 93 says where there is such a possibility, don't touch. Yes. Because it's about money that's not yet spent.
That is not our understanding of the interpretation of Attorney.
No, it's okay. Attorney General, it's okay.
That's my Lord.
So, okay, that concludes on that issue on your side, not so? The submission?
Yes, my Lord.
Okay, now can we proceed?
Now, my Lord is having successfully convinced you on that.
No. I'll tell you what I told Learned Counsel Elias yesterday. Don't be duped by our facial expressions. You might sweat and celebrate at the end. Similarly, you might celebrate and begin sweating at the end.
My Lord, apparently I have nothing to celebrate. I now call upon Christine Kawa, Acting Director Civil Education, submit on issues number 8. No. It was supposed to be me submitting issue number 6G. 6G. My lords, when I recall our area submissions, both myself and the Solicitor General, we think we have adequately covered issue 6G, and we don't want to bore you with repeating our
Actually,
arguments.
you took an hour on 6G. Without referring to it, but everything you said for that 1 hour was about.
We reiterate our submissions in respect of issues number 1, 2, 3, and 4 to cover issues, the issue 6G. And we save your time, my lord. So, President Kawa, could you submit on issues number 8 and 10?
My Lord, before I submit on issues 8 and 10, I would just like to add to the submissions about the certificate of financial implication that matter, I believe, will be fully covered by the expert witness who will come, Mr. Makanizi, because he's aware of those. And I'm glad that he will come, and maybe after that the court may shift its view on a few things. Appears, my lord. Most obliged.
Learned Counsel, let me re-emphasize, let me reiterate this point. Whatever questions we ask you, however so much we prick you on the ribs and what have you, don't leave this place with the notion that the court has made its mind on any matter. No. And I speak for all my brothers and sisters here. No. That's why I'm saying, do not get duped by our facial expression, our apparent indignation, our apparent belligerence, and our apparent friendliness. All those are nothing. We seek to milk even a stone, if need be, to get milk out of a stone. At the end of the day, we will give a very considered opinion in our decision.
I'm most obliged.
And we will, let nobody be stampeded, let nobody be intimidated, because you are here to present your case, you are here to persuade us to use your lens to see the issues before us.
I'm most obliged, my lord. I can only say that sometimes the questions from the bench are rather too many, the interjections are too many, and sometimes as counsel we get bombarded and we cannot present our case. That is the feeling at least I have from this side. Yes, my lord. Of course, as that.
But if you come with written notes and speech to read it here, you can't.
Because you've been diverted from the
things we have.
We are not saying
we have to ask you from each of these volumes.
Yes, my lord, and that is perfectly in order.
Yes.
But I'm just telling you what don't you just start? I'm starting, my lord.
That's why you're a director.
Yes, I'm
Director, acting director, have you come prepared?
I am very
Can you
prepared.
start?
Yes,
Start submissions.
So I will submit on issues 8 and 10. Issue 8, my lord, is whether the passage of the Act without observing 14 sitting days of Parliament between the second and third reading was inconsistent with and or in contravention of Articles 262 and 263(1) of the Constitution. My lord, the case for the respondents is that indeed there was no inconsistency, neither was there a contravention of the said articles. My lord, I will take you to Article 262 of the Constitution. Provides for the amendments by Parliament and provides that a bill for an act of Parliament to amend any provisions of the Constitution other than those referred to in Articles 260 and 261 of this Constitution shall not be taken as passed unless it is supported at the second and third readings by votes of not less than 2/3 of all the members of Parliament. Clearly, this seems to have no relationship with the 14 sitting days. However, Article 2631 of the Constitution of the Constitution provides that the votes on the second and third reading referred to in Articles 260 and 261 of this Constitution shall be separated by at least 14 sitting days of Parliament. So that is where the contention in this case is. My Lords, this contention seems to have come up at page 5263 of the Hansard, where there are some arguments which are made by Honorable Mafabi Nadala, and they begin at 5262 of the Hansard. I will refer to the Hansard, I will refer to the affidavit of Jen Kivirike in the case of Honorable Paprika.
Which tab?
Page 5262, my Lord.
5262?
Yes, Nandala Bafabi.
Nandala Bafabi, there states that I want to move an addition of a new clause. And he's addressing the chairperson and says, since you allowed Honorable Michael Tusinde to raise an amendment, I want to bring an amendment to Article 105 of our Constitution to introduce term limits. He then further goes on to say, I want to say that a person shall not hold the office of the President for a term for more than 2 terms. In addition to that, this should take effect from the next Parliament. He further says that we do not want to count this Parliament. We want this one to be entrenched as F in Article, as paragraph F, chapter 5, under amendment.
This was in the committee.
This was in the House. The Committee of the House. Yes, my Lord. That is where the problem and the issue seems to emanate. So I...
And what does Mr. Dongoto say? That's the first sentence on
Mr. Odongoto says, Madam Chair, that would be a good trade-off.
For the extension of 2 more years to the 5 years.
He said, that is what he says. I will not impute
Thank you, proceed.
But
so it was not about the interests of Uganda, but it was about trading off. Barter trade.
My Lord, I will take you to the last paragraph at page 5262. At that paragraph where the chairperson is addressing where she puts the question to the House. She says, Honorable members, I put the question that Article 105 be amended as proposed. Then to the next page, that first italics brackets is question put and agreed to. So the question here was about the amendment of Article 105.
I have spotted something interesting in Bill 5263. Nanda Ramapara.
Yes, my lord.
Madam Chairperson, we have moved both amendments that this article be entrenched under Article 260. We entrench it to be under F and we add.
Yes, my lord.
Earlier submissions that it was not under Article 260.
You see, my lord, that's why I'm taking you through, and I want to make a chronology.
And also we can help you because you have it in the very correct time. After Udongo Cho, chairperson of the committees, legal and environmental, Mr. Both, since they're being put in a very difficult position for this introduction of this motion by other private members after the committee has reported to the House. You see, this would be very difficult because they have already done their work. And yet somebody is doing this in the House.
Yes, my lord. They may have been put in a difficult position. I think it was a difficult position.
But the tyranny of the majority will not listen to this.
My lord, the record will speak for itself. I will not impute more than what is in the record.
Okay,
nevertheless,
proceed.
Mr. Nandala Mafabi goes on to say where Honorable Justice Kakuru has pointed to. He says, Madam Chairperson, we have moved both amendments that this article be re-entrenched. There are some interjections there. Then he says, under Article 260, we entrench it to be under F, we add and brackets 2. The justification is to avoid it being changed at will. My lord, do I have your attention?
Yes, please. It was only our eyes on the paper, our ears were with you.
My lord, then the next paragraph, the chairperson of the House now says, okay, honorable members, I put the question that this clause, and for emphasis, my lord, you should underline clause because it was not underlined, says, okay, honorable members, I put the question that the clause be further amended as proposed. The question was put and agreed to. Further down, my lord, you will see the submissions of Mr. Rukutana. He was appearing there as Mr. Rukutana, I think in his capacity, speaking in his capacity as a member of parliament, and he says,
as I was there.
Here. He's not being addressed here as Mr. He's not. Okay, let me go to that. He says, Mr. Rukutana, Madam Chairperson, I want us to move well aware of exactly what we have just passed. The motion, Honorable Nandala Mafabi, if I heard him very well, was to restate term limits. We have not had an occasion to debate that motion. There's an interjection there. If we had occasion, we would demonstrate that the same reasons we had used to remove the age limit are the same reasons for which in 2005 we removed the term limit. Secondly, it goes on to advise. But their chairperson, who is in charge of her house, says, honorable members, she makes a ruling was the issue to the political system. So she makes that clarification. Then immediately thereafter, Mr. Okupa says, Madam Chairperson, the Attorney General should be courteous. You had ruled on this matter. Is he in order to proceed that way? The Chairperson says, no, we voted on it already. I put the question that the title do stand, then they continue.
But the question before the House was, is it proper to graft a kituba tree on a fig tree? That was really what was before the House. But somebody was concerned.
So, my lord, my submission is what Mr. Nandala Mafabi was referring to was Article 1051, which That is the article he was referring to. And when he has referred to that, my Lord, we know that the Speaker ruled on the motion and said this is not as Mr. Rukutala was advising. So,
my Lord, Council on page 5263.
Yes.
On the side 8.57.
Yes, my Lord.
Mr. Rafael Majesi says, I beg to report that the committee of the whole House has considered the bill entitled the Constitutional open bracket amendment close bracket number 2 bill 2017 and passed the entire bill with amendments and also introduced and passed new clauses amending articles 77, 181, 29, 291, 105, and 260.
Yes.
I beg to report.
Yes, and it does report. And that is all it does.
This morning we were asking whether 260 was
No, my Lord,
amended or not. It appears it was simply dropped at the legislative drafting process, but it was amended.
My Lord, my submission and our case is that what Magezi stated here and whatever else is stated in this hazard is a true reflection of what transpired
in the House.
It does not, however, mean that the opinions formed are the correct opinions, or that there are no clerical mistakes, or that there are no views which this court can turn around. And this Article 260, if it had been the position of counsel for the petitioners that 260 was amended, it would have been reflected in the bill. It's not.
No. The question is, the records are very clear. And in case you've forgotten, these are records brought before court by yourselves, not by the petitioners. So we read them as they are. You've not qualified the correctness of the record. You've in effect certified their correctness. The move of the motion, the present of the bill, at the end of the process, now reports on what the bill has achieved. And the relevant one before us in this issue is that it has amended Article 260 of the Constitution. Then the bill, the act that comes out doesn't say that.
My Lord,
do parliamentary councils have the right to come up with an act that does not reflect the decision of members of parliament?
My Lord, I beg your pardon?
Do parliamentary councils have the right to come up with an act that does not reflect the decision of parliament? Or put differently, after Mr. Majesi made that report, did parliament resolve anywhere, yet on record, where they say, okay, we want this entrenched in the Constitution in a separate article, as was being argued this morning? Is it anywhere?
My Lord, our submission is that there was no amendment of Article 260. And if you followed my Lord,
despite what Mr. Magezi has,
I have seen the record.
That's what was voted.
Let me.
They went to vote on those amendments.
My Lord,
that there is no other record other than yes, no, yes.
Now, my Lord, I have taken you through the previous one.
Okay.
If you look at paragraph 8.57 at the end, there is no question put and there is nothing agreed to. So for each clause, there will be a question put and an agreement made. It is not here.
Oh, so you are saying this bill was made into parliament without any question put? So we should annul it on that ground?
My Lord, I have taken you from 5-6.
Why don't you look at what continues in 8.58? Then he says, Madam Speaker, I beg to move that the report of the committee of the whole House be adopted. Honorable members, I put the question. And then, what is that?
Now,
Question put and agreed.
this is
report adopted.
My Lord, this is... I have explained what happened clause by clause. Now I come to here where there is the report of the committee of the whole house. The first paragraph is 8.57. After 8.57, immediately after that, there is motion for adoption of the report from the committee of the whole house. Then 8.58, Rafael Majezi then says, Madam Speaker, I beg to move that the report of the committee of the whole house be adopted. Now, my lords, on this record, there is a report of the whole house. If you read the report of the whole house, you will find that there is nowhere where 260 is mentioned as amended.
No, it is.
The report of the committee.
Where is the report?
Whether there is or not, this is Magezi's own personal view. This is what he said has been amended. That's what the speaker put to the house.
No, that's not what the speaker put to the house, my lord. My lord, that's not what...
That's what there was a report that the objected to
Is that the opinion of this court?
What he wisely objected to, the Attorney General wisely
My lord,
objected to.
I have given you the reasons why...
You are the one who said that this was regarding the report. So we are asking, where is that report that does not include?
I will find the report in a minute, my lord, and
No, it's not attached to this document, standard report.
It is attached to one of the pleadings. I think the petition of Karumanga contains that report of the whole house.
He said whatever he said. Look at the proceedings. Nadara Papa's motion was brought during that debate and was added. So there is no way that report would have been done. Because Nadara Papa came at the end. But without looking for the report, just go to page 563 and you will see the house resumed and the speaker presiding. The heading, report from the committee of the whole house. And that is the only report. That one is the report. That is the report. That paragraph is the report. There is no other report. The others are proceedings. This is the report that was reported.
Now, my lords, if you flip over that page, you'll find that the proceedings are still continuing at 5264, where the report is adopted.
Yes. The report which is on that paragraph, which Magazine 8.57. That is what was adopted. What else?
Maybe Honorable, maybe Acting Director, Council Kawa, is there Honorable Majesi said it loud and clear that Article 260 was being amended. Is there anywhere in the answer excluding this article, or that what he said was not true?
My lord, I'm not very sure if there is something in the Hansard, but what I'm sure of is that under the acts of the Parliament Act, the clerk is supposed to give a certificate of correctness.
My lord, I seek your indulgence. We have here Council Solomon Chirunda, who is a council of the Parliament, and he wants to clarify.
You don't need some.
No, to clarify.
But what my lords are asking
Is what you mean is
He's on record as
part of
counsel.
your team. Okay.
For the record, I'm Solomon Chirunda, and I would like to refer you to page 5262. 62 of the answer that is requested. When Honorable Nandala Mafari moves to amend, he says, I want to ask the chairperson about inserting, after clause 3, amendment 105. So the clause in question, all through the deliberations, was amending Article 105.
We have the same document because at page 5263, the same Nandala Mafadi says, Madam Chairperson, we have moved both amendments that this article be amended under Article 260. Which one are you reading?
I said 5262,
Yes.
where the conversation
That
starts.
said, stop there.
And I'm going to correct that, my lord.
Correct.
No, I'm leading you and I'm going to tell you what happened, citing a provision of the law.
No, that's submit.
What? I'm most obliged, my lord. It is our submission that the clause under discussion was amending 105.
Then why was Nandala Mafadi at page 5262 saying that that this article be retrenched under 260 and we retrench it to be as under F, meaning F of 260, and we add a 2. The justification is to avoid being changed and will.
My lord, the question that was put by the speaker was on the clause under discussion. And what was the clause under discussion? It was amending 105. A Hansard is a verbatim recording of the whatever happens in the house. Even if the landed attorney general abused me in the house, the Hansard will capture that. When everything is done, and they are now extracting the bill to do the presentation copies, the clerk, under Section 8, Section 8.2 of the Acts of Parliament Act, which is already before you, my lord, is permitted to cause to be made in the copies such corrections as relate to misprints, typographical errors, and wrong references, if any, where necessary, and carefully compare the copies of the text of the bill first. And if copies are found to be correct, sign on each copy a statement in the form set in Part 1 of the second schedule of this Act. That is why
applicable.
That is
if
why
it were applicable, we do not have spent the whole morning trying to explain to you or to us that you cannot amend 105 without amending 260, which was the argument. So it cannot be a correction. It just shows that Parliament at all times was aware, the mover of the motion was aware that the impact of amending 105 is that 260. He did not only do that, he even suggested the sub-clauses F and D. How can that be a correction? Because it is logical. You see, a correction must come when there is no logic.
And Councillor Chirunda, are you implying that what is stated in the hazard, particularly on page 5263, Honorable Nandala Mafadi refers to Article 260. Honorable Magezi also refers to the same article. Are you implying that what is on this page of the answer Is he incorrect?
You see, if they were referring to Article like 43 or 620, then you can talk about the correction. Because that Article 260 is about the interest provisions. If it was referring to an article that talks about the powers of the IGG, you could say that there was a need for a correction.
My lords, if I may allow to put this on record, the article under consideration was Article 105. However, it is our submission that both the Honorable Nada Mafavi and the Honorable Majesi in his reporting erroneously referred to Article 260. And when the clerk was collecting the record,
Prudential, with over 170 years of existence. Don't worry about your child's future education. Be happy with True EduSave and let's face life together. Tulinawi. Prudential.
Wake up to cuddles like never before.